Nigerian justice sector is an interplay between all the arms of government. As the judiciary interprets the law, the executive arm expectedly executes it, while the Office of the Attorney General, the Federation and Minister of Justice, as well as other non-state actors, all playing specific roles to uphold constitutional provisions on the protection of the rights of the people, adherence to the rule of law, and ultimately deepening the country's democracy. Now, in retrospect, 2019-2020 legal year has been described as a very decisive era for the Nigerian judiciary. It was a year characterized with cases that intrigued the public and no doubt challenged the capacity of the judiciary to uphold its constitutional mandate as the final arbiter in cases between individuals, corporate entities, and government. Now, the report of the United Nations Office on Drugs and Crimes, UNODC, as well as the National Bureau of Statistics, NBS, labeling the judiciary as #2 on the corruption index, also questioned the ethical and professional standards of both the bar and the bench. On the positives, some members of the inner bar recognize efforts by government to give bite to financial autonomy for the judiciary, but that's at the state level. This is in addition to effective implementation of the Administration of Criminal Justice Act 2015, which has paved the way for quick dispensation of justice. And as the judiciary commenced legal business for 2020, it is expected that, barring any unforeseen circumstances, it will remain in session until the Easter break, and hopefully too, aside from the upcoming Edo and Ondo states governorship elections due sometime in the year, political matters in the course list would have been dispensed with. So, the question is, what are the expectations of Nigerians from the justice sector this year? That is the focus this week on Late Edition. I am Claire Adilabu Abdul Razak. Thank you for joining me. Abubakar Malami is the Minister of Justice and Attorney General of the Federation. He has over a decade experience as a senior advocate of Nigeria SAN, and as a top-level professional, he has over 3 decades experience practicing in both public and private sectors. He is described as an astute legal practitioner with impressive stint in the academia and the judiciary. His areas of bias include justice sector and anti-corruption, and has displayed great competence in legal drafting, legal research and analysis, leadership and networking, soliciting and advocacy. He served as chairman, high-powered Presidential Committee on the extension of the Continental Shelf, chairman, Presidential Interagency Committee on recovery of AMCON portfolio loans. He was also the chairman, Presidential Implementation Committee on the financial autonomy of state legislature and judiciary, supervising minister, Presidential Committee on Prisons Reforms and Decongestion. And he was also chairman, Presidential Advisory Committee on Prerogative of Mercy. And on the political side, Abubakar Malami, SAN, was a member of the Constitution Subcommittee for the APC in 2014. He was also a member of the National Conference convened by the federal government in 2013 and has many, many literary works to his credit. My second guest, Professor Yemi Akinseye George, is a legal practitioner and academic administrator. He is a professor of public law and president of social legal studies. He is the principal partner of Yemi Akinseye George and Partners, which provides quality legal services to people within and outside Nigeria, and has competencies in constitutional, criminal, corporate, commercial, banking, and financial legal practice. Indeed, Professor Akinseye George is the foremost national legal expert on the Administration of Criminal Justice Act. He served as a special advisor to a one-time Minister of Justice and Attorney General of the Federation. Now, Professor Akinseye George is a fellow at Davis Center at Princeton University. He is a member of many national and international legal professional bodies, including just a few: Nigerian Bar Association, Law Professors Network, University of Pittsburgh, International Society for the Reform of Criminal Law, and Network of University Legal Institutions. Gentlemen, Leonard said, thank you for finding time to join me on Late Edition.
Thank you, Claire.
Thank you very much.
So let's start with the Justice Minister. Let's begin with your office now. In obedience to the rule of law, let's quickly evaluate how government fared in 2019.
Well, I think in doing justice to compliance with the rule of law assessment, the antecedents, where we were before and where we are now, is indeed very much in place. You cannot do justice to compliance or otherwise to the rule of law without having a comparative basis as a parameter for conclusion. Here we are in a country where at a point before coming in place of this administration, arbitrariness and impunity was at a point and order of the day. A situation whereby a government in place could consider and perhaps execute the possibility of a clear extinction of perhaps a community on account of perceived aggression to the policies of government. Now here we are in the course of development of a nation whereby people are not only given an opportunity to express their minds. Freedom of expression is sustained. Right to approach judicial processes for the purpose of contesting the position of government is upheld. And indeed, above all, legislations that are targeted at enforcing the rights of people, legislations that are targeted at supporting the capacity of institutions with a view to establish independence, with a view to be assertive in the discharge of their duties and functions, are in place. So within the context of where we were, a situation that more or less tolerates, more or less establish impunity and arbitrariness in the conduct of governance, shifting grounds to a situation whereby freedom of expression is upheld, whereby right to approach to the court is guaranteed, whereby enforcement of the rules, enforcement of the orders, enforcement of judgments of the courts are upheld. I think within the context of obedience, the government of President Muhammadu Buhari has indeed demonstrated an unprecedented compliance with the orders, judgments of the court, and indeed established due compliance with the rule of law.
That's interesting. Prof, let's take up from where the Justice Minister said with regards to impunity, arbitrariness in the conduct of governance by government. He says this administration has demonstrated unprecedented compliance with regards to the rule of law. If you evaluate, from the outset of our democratic dispensation and now, what's your evaluation? How do you evaluate us?
There are a couple of points which must be considered. When you talk about government compliance with the rule of law. You see, an important component to the rule of law is human rights. Human rights is at the center of the rule of law. In fact, the whole essence of the rule of law is to create a platform for equality before the law, for access to justice, for reduction in arbitrariness, so that there will be stability in the system, predictability in the system, and respect for, institutions. I would say, without any doubt, that since 2015, Nigeria has begun to move upwards in regards to the issue of accountability of government. Without necessarily agreeing or disagreeing, with Honorable the Attorney General, one point he made that is factual is that there's a reduction in impunity. Shortly before the coming of this government in 2015, we were moving towards a dangerous precipice. Nigeria was at the edge. People did whatever they wanted to do. It was as if people were, many highly placed people were above the law. The interest of the country was at the lowest ebb. The pursuit of the interest of the masses was at the lowest ebb. But in 2015, when the administration came, sanity was restored. Impunity began to be reduced. The culture of impunity was tackled. That's why today people are very careful, because you will be made to account. And the courts have followed suit. The courts have followed suit. In the past, there used to be said that there's presumption of innocence. So even if you took everything that belonged to everybody, something that belongs to everybody, you loot the treasury, the duty was on the prosecutor to explain, your guilt, to justify the prosecution. But now, the court in Daudu, the Supreme Court has said that where a man is found to be living beyond his known means of income, he has a duty to explain how he came by those assets. For me, these are signs that we are returning gradually to normalcy.
I like the Minister. You've ticked up some positives in terms of restoration of sanctity and reduction, of course, culture of impunity. How has government, aided in these areas?
Now, if you are to look at it from the perspectives of the role of government in the sustenance of civil order as it relates to conduct of governance, you have certain components that you have to factor to mind. Components, for example, like legislations. We have in place legislations that are indeed enforced, that were targeted at bringing about the desired sanity, not only in governance sense, but in judicial sense for that matter. For example, let us take a case of P&ID that I had cause to discuss some times back. The manifest impunity that could visibly be seen arising from the way and the manner the contract in its own right was consummated, sidelining the right of the institution, the Office of the Attorney General, Solicitor's Department, to vet the agreement. The right of the Department of Petroleum Resources to give the required necessary approvals. The right of the Federal Executive Council to approve the contract. All these things, these components that are intended ordinarily to ensure things are done in compliance with due processes, were at a point sidelined. Now, along the line, the manifest conclusion is that impunity was allowed to set in governance. So now this government comes in place, sanctioned investigation relating to the sidelining of these processes along the line. The fact that due processes were sidelined with impunity before coming in place of this government is a clear manifestation and demonstration of the fact that we are now changing direction for the better in terms of due compliance. And then the fact that along the line, the government commission and sanction investigation to indeed unravel the conspiracies, the compromises in the system that allowed for the signing of an agreement that is injurious to the national interest, an agreement that has the potency eventually of depriving the government of an asset worth over 1/3 or around 1/3 of its national budget. Is indeed a manifestation of the fact that we are moving from a culture of impunity to a culture of due process, even in terms of manifest governance process and procedure.
Are all arms not complicit in this whole saga?
What we are saying is that element of complicity now is being addressed, being tackled, and indeed being unraveled by the commissioned investigations relating to the impunity, relating to the conduct, inimical conduct that has the potency of shortchanging the national economy. And by so doing, we are indeed moving towards a positive direction in the art of sustenance of good culture as it relates to governance, and that translates to the enthronement of the rule of law, enthronement of due process, and enthronement of transparency and accountability in governance.
I'll put you on the pause for a while. I'd just like to ask, how many government officials are complicit in that, and what's the way forward now?
Well, as you rightly know, when this award of over $9 billion was made against the interest of Nigeria, His Excellency President Muhammadu Buhari commissioned an investigation into it. And there were certain convictions, there were certain arraignment before the court of some persons and personalities that were believed to partake in the processes of compromises that resulted in the shortchange against the interest of the federal government. So what I'm saying, in essence, there are line officers that were supposed to have acted one way or the other that were found shirking in their duties and responsibilities as it relates to the protection of the national interest. They were charged to court, and some of them convicted, and there are cases ongoing. But the bottom line is for you to understand that the Ministry of Petroleum Resources, sizable number of people that had acted one way or the other were involved. And then along the line as well, within the context of those that are saddled with special responsibilities associated with the drafting of the contract, with the vetting of same, prosecuting same, and profiling and providing necessary opinions. And indeed, having same placed before the Federal Executive Council for approval. Investigation is ongoing. People have been charged to court, and people have been convicted.
Prof, would you consider this a landmark one for the office of the Minister of Justice, for government really? The PNIDs,
Yeah, the government has responded very well. Government has responded very well. I mean, this was a mess that was created by by some guys in the previous administration, who capitalized on the impunity, the atmosphere of impunity in the country, to perpetrate massive, wrongdoing against the country. So the government has responded so far. I mean, I've been following the activities, of the Federal Ministry of Justice. So I think accountability, has begun to replace impunity. So I think.
So this is an evidence.
Yeah, this is one of the signs. It's no longer business as usual. It's no longer business as usual. Wrongdoings in the past have been corrected. You find that highly placed people who are never accountable in the past are now being held to account, regardless of political party. Cases have been concluded. In the past, the courts were not able to conclude cases. All you needed to do when a charge was instituted against a high-profile defendant was his lawyer goes to court, files an application for stay, then files some appeals. And then the matter keeps going back and forth from the High Court, Court of Appeal to the Supreme Court. Several years, we had movements, we had judgments, but there were no justice. Cases were never concluded. Hardworking judges could not see, their efforts actualized. They could not see the justice could not be delivered.
So the process is better now?
No, significantly better, significantly better.
Yes. Justice Minister, I know that your office oversees the activities of the anti-graft agencies, the EFCC, the ICPC, and all that. Can you give us an insight into the level of cooperation or relationship?
The function of rule of law is never exclusive. If you are talking of collaboration and the context of it within the in the scheme of things as it relates to rule of law, you have to consider it from the perspectives of the respective roles of the stakeholders. If you are talking of fee and ID, for example, now as we are talking, you require one, the local collaboration. It is never within the context of the office, the functions of the office of the Attorney General to investigate issues. Investigation is indeed the function of agencies like ICPC, EFCC, the police, among others. So without these institutions playing a role of investigation that have the potency of providing the factual proof of evidence, there is no way the office of the Attorney General can now initiate prosecution, because in the act of framing charges, in the act of filing them, you require proof of evidence. And the function of that provision is the function of the office of these other institutions. If you are talking, for example, of international, perhaps, connection to the investigation that has to do with P&ID as well, you require the services and support of the foreign institutions, for example. If you are talking of P&ID, it's a company that is registered in British Virgin Island. So you require an international support of the British Virgin Island for the purpose of establishing the authenticity of the existence of the company as an entity, corporate entity, identifying who are the brains behind it in terms of directorship, identifying what are the objects of the company and associated components. So you require international collaboration by way of central authority unit engagement between Nigerian component and the VVI component, for example, for that matter, for the success of investigation.
Okay, so not merely an oversight, whatever.
So it is no more. It is not about a mere oversight.
Okay, you touched about functions, and I would like for Prof. I'll get back to you on that question, but what exactly are the functions of the Office of the Attorney General of the Federation and Ministry of Justice? I ask because in the past there have been calls for a separation of the two offices.
The Office of the Attorney General of the Federation is the principal legal office, or the chief legal office of the federal government. It is the weekend of all the other ministries, in the sense that all the ministries must depend on the Attorney General, on the Ministry of Justice for guidance, legal advice, legal support, even though there are some of them who have in-house lawyers and so on. But most of the lawyers in most MDAs and their departments and agencies are lawyers, seconded from the Office of the Attorney General of the Federation. Then the Attorney General is the chief defender of the interest of the public.
The Attorney General?
Oh, yes, is the chief defender of the interest of the public. you know, even though in this country we don't sufficiently appreciate or understand the work of the Office of the Attorney General. Police, investigators, the prisons, all of these people are supposed to be under the supervision of the Attorney General. But our Constitution is not so, it's not explicit on this point. You know, so that's why it appears that many things which are you know, things are not exactly the way they're supposed to be in many respects.
How does that affect dispensation of justice, equity?
For example, police, for example. The police, you know, in these other democracies, the police, law enforcement, all of these agencies are under the supervision of the Attorney General. Because when they run afoul of the law, the Attorney General will say, no, you can't do that. But here you have a justice minister, you have a police affairs minister, who may not be a lawyer, yet who has to supervise the police. You know, so that's why a lot of times we talk about the need to rethink our Constitution, to rejig the Constitution. And that process has already begun. Many aspects of the Constitution have been touched, you know, have been improved upon progressively.
What aspects? Just for us to know, what aspects are you talking about?
One of the major areas, you know, it's not, for me, it's not about separating the Office of the Attorney General and Minister of Justice. I've worked in that office before as an assistant to 3 attorneys general. By the way, you said 1, I assisted 3. You see, it is difficult to draw the line between the office, the functions of the Attorney General, and the office and the functions of the Minister of Justice. You know, I don't know if the incumbent Attorney General would agree with me on that. But from my experience, as an assistant to 3 attorneys general, it is difficult to draw the line. But what we need to do is to rightly position. The only ministerial office that is mentioned in the Constitution is the office of the Attorney General of the Federation. All the other ministerial offices are not mentioned. So the president can reorganize, do without those offices. But the office of the Attorney General and Minister of Justice is written expressly in the Constitution. So all agencies of law enforcement, police, military, even DSS, security agencies, ought to be under the supervision of the Attorney General, because they have a tendency to overstep their bounds a lot of times. Look at what happened recently when the Attorney General had to direct the DSS to comply with some orders of court. He had to give instruction. That was what, you know, that's some of the things we are celebrating.
But it would appear that even the other agencies are somewhat on their own. I mean, for want of words.
Because of the way our Constitution is fashioned. A lot of them do not see themselves as being under the Attorney General. But of course, look at the power of prosecution. Police will be claiming power of prosecution. A lot of agencies will be claiming, of course, they all have powers of prosecution. But the ultimate repository of the power of prosecution is the Office of the Attorney General of the Federation.
Justice Minister, how does that affect the effective functioning of your office?
Well, you see, I have labored to underpin the essence of collaboration. And to the extent that we have succeeded as a government in forging the attitude of collaboration among the agencies of government, in all sincerity, we are recording a lot of successes. And that collaboration is not a collaboration that is restrictive and exclusive to the executive arm of government, for that matter. However much the executive desires to advance the rule of law, both in terms of speed and compliance, in the absence of legislative legal framework, it couldn't have been possible. So that is the more reason why when the need arises for the involvement of speedy determination of justice, the executive thought of the need for administration of Criminal Justice Act, and then make an overture and approach to the legislative arm of the government, which eventually put in place a legislative framework by way of having enacted Administration of Criminal Justice Act. When the need for timely determination of election petition matters arises, the executive realizes that judiciary on its own, exclusively without recourse to the legislative framework couldn't have achieved the desired result, and then we have to have recourse to the legislature for constitutional alteration to bring about time factor element in determination of cases. When the need arises, when we now as well, for example, realizes that while higher profile cases were being prosecuted before the judiciary, those standing trials for high profile corruption cases were using the instrumentality of technicalities associated with judicial process to circumvent the speedy determination of cases. We had, as an executive, we had to look at the possibility of bringing about Executive Order number 6 that is designed to, one, preserve the asset so that at the end of the day, while the prosecution is ongoing, the asset in contention constituting the subject matter of corruption charge is not dissipated. And then we realize the need as well to restrict the movement of those standing trials on corruption cases so that at the end of the day, if the need arises for international collaboration, they do not get out of the country at ease to now to compromise the investigation process. So it is about collaboration. What matters most is the ability to collaborate, is the ability to work together locally and internationally, and that is the more reason why Nigeria.
And are you all working together?
We are. That is manifest arising from the fact that the course of justice is now evolving in terms of speedy determination, because in the absence of collaboration, in the absence of cooperation and working together, it couldn't have been a reality.
Justice Minister Abubakar Malami and Professor Akinseye George, just a moment. We'll be right back to continue our discussion. You're watching Late Edition, and we're looking at the justice sector, of course, in retrospect 2019 and projecting into the new year. We'll be right back. Welcome back. This is Late Edition. My two guests are still with me, Justice Minister Abubakar Malami and, of course, Professor Akinseye George, Senior Advocate of Nigeria. Thank you, gentlemen, for still staying with me. Now, let's look at freedom of speech. You know, those who criticize, latest, attempts to regulate the social media hinge it on the fact, on what they say is infringement of certain provisions of the constitutions on fundamental rights. And of course, we have seen, clamp down on some individuals who have made certain utterances deemed to, be threats to our national security. I know Professor Akinseye mentioned this, but how can, we, Ministry of Justice, strike a balance between what is freedom of speech and what is national security?
In addressing the freedom of speech or fundamental freedoms, human rights freedoms established and enshrined in this Constitution, the starting point is for us to appreciate and understand that they are not rights at large. They are not rights that are open-ended. And within the context of liberties and freedoms that are accorded to individuals and citizens, you must strike a balance having regard to the public interest. And it is important at this juncture for you to appreciate the fact that one of the major functions of the office of the Attorney General as constitutionally established is the protection of the public interest and the sustenance of the interest of justice. Now, the balance. comes into play within the circumference of appreciation of the two contexts, the individual freedom, individual liberty, and the public interest. Your conduct in the exercise and enjoyment of the freedom of speech and all other rights and privileges accorded to a citizen by the Constitution must be exercised with particular consideration to a larger interest. You cannot, for instance, relying on the freedom of expression, take steps by way of making utterances that has the potency of triggering actions that may affect the national cohesion, national interest, and bring about chaos in the governance and the enjoyment of public interest. So simply because you are entitled to freedom of expression, you are not in any way accorded a right at large to make inciting statements, inciting utterances that have the potency of bringing about chaos in the governance, bringing about unnecessary disorder and disharmony. So what I'm trying to state in essence, that the right, the freedom of expression, and whatever freedom is accorded constitutionally, is not a freedom or a right that is exclusive, but is a right and freedom that is juxtaposed within the context of limitation of the promotion of public interest and sustenance of order in the conduct of governance and in the society.
Thank you. Professor Akinseye, you raised this issue as a civil and political rights challenge. With regards to certain cases which have been termed controversial, I'm sure you know the cases I'm talking about. There was Showore, there is Dasuki, there is even the proscription of... Do you think that the office of the Attorney General has indeed executed effectively the protection of public rights?
I think we have overflogged these issues. We need to start moving forward. The right thing has been done when these guys who were detained for unnecessarily long period have been released.
Yes, but it took...
Yes, the right thing has been done.
The critics will say, look, it took long in coming.
Yes.
Yes, and probably they attribute whatever decision that was taken, to some external pressure.
Look, we live in a global community. We live in a global community. Just as has been said, my right to stretch my hand as I like ends where your nose begins. Oh yes. It is the society. There must be a society before we can talk about human rights. When
the decision was taken for the release of Showore, for instance, a lot of people wondered why it had to come, why a letter had to be written, from the office of the Attorney General.
Well, you have to look at it, one, as has been rightly stated by my learned brother, Silk Akinseye George. The Attorney General is the Chief Law Officer of the Federation. The Office of the Attorney General is the custodian of the public interest. The Office of the Attorney General is the custodian of the interest of justice, and has as well rightly been reinforced by Professor Akinseye within the context of the operations of the interest of justice, the public interest, among others. The Office of the Attorney General had the responsibility of prosecuting on behalf of the government where the government is taken to court. Now, a scenario needs to be narrated. In the discharge and functions, in the discharge of the investigative functions of the enforcement agencies like DSS, the need arises for an investigation and a person is taken to custody within the context of their statutory powers. And then the matter becomes a judicial dispute. He still remains in custody, and then the person that is taken to custody is now eventually applied for bail and is granted bail while he remains in the custody of the state while investigation is ongoing. A court of law, the status quo here relating to the person involved is that he is in custody of the state, and then he applied for bail and an order granting bail is granted. So the rule of law element of it that you need to appreciate properly now is when an order granting him bail is made by a trial higher court. Is it an order that has to be unconditionally, immediately, and without further recourse complied with by the state that is conducting investigations over allegations for which a person is taken to custody, or within the context of the rule of law, there are other options often to the government as a party before the court? My answer is there are options open. Among the options is one, you may consider filing an appeal and stay of execution. If you file as a government, you have an appeal pending, and then you have an application for stay of execution that lasts for 10 years. Nobody within the context of the rule of law as it operates in Nigeria can charge you with disobedience of the court order. Why? Because one, you are submissive to the court of law for the determination of a dispute. Two, an order is made by the court of law in respect of which judicial hierarchy allows for an appeal and an application for stay of execution, which you have taken benefit of by way of appealing the order, by way of filing an application for stay of execution of the order. So as long as these two remains within the judicial cycle for as long as possible, you cannot be adjudged as being in disobedience of the court order. The same thing where you file an application for review of the terms of the bail, for example, before the court, and that application is pending for determination. Nobody can adjudge you guilty of being in disobedience. Maybe the better example that may come to light, for example, is when you are in contention with someone relating to the ownership of a house, you are in possession, and then a judgment is given by a court of law declaring that you that remain in possession are not the rightful owner. Do you immediately, unconditionally, and without further recourse, surrender possession without challenging your right through appellate process?
Of course not.
That is the way the rule of law, as far as the Nigerian situation operates. You can only be adjudged guilty of non-compliance, guilty of disobedience to a court order when an order is made and you have not taken steps to challenge it by way of an appeal. And if you do by way of an appeal, you file an application for stay of execution or perhaps for review or setting aside, then apparently if one of these elements, appeal and stay of execution, challenge by way of review, and or perhaps filing an application that justifies the setting aside of the order, then the idea of disobedience to court order does not arise in the circumstances.
Okay, let's look at some of the challenges. We have very few, limited time to write on. Some of the challenges bedeviling, the Nigerian judiciary, and I'm going to mention a raft of them so that we'll just take them all at once. One, we look at, of course, the general jurisdiction that, judges are, invested on judges. We hear that a particular, judge will probably have so many, cases, to deal with. We also looked at docking congestion. a number of them. For instance, I'm told that last year alone, there were over 100 cases pending before the Federal High Court. That's in 2019, for instance.
In one judge?
Yes.
We're talking about just one judge?
Just one judge, you understand. And there is also the issue of overloaded schedules, where you have a single judicial division with few judges, with as many as over 700 cases. And there was mention of some states, where you find it. So really, Prof, how can the judiciary, be made to be better, or more effective?
This is a very good question. This is a very good question because the workload of the judiciary has increased and continues to increase. So it is necessary to look at the working conditions of judges. It is necessary to look at the salary of judges. Now the government has given effect to minimum wages for a large category of workers, which is also something we need to talk about. That is improving socio-economic situation. That's a way by which you can also lift up more people from out of poverty by increasing. So the same ought to be extended to the judges. Some judges have been on the same salary for about 12 years. Yes, and the Constitution says the government cannot reduce the salary of judges, but there has been no direct reduction, but because of inflation, because of the reducing, the falling value of the coin, of the dollar, of the naira, so it is necessary to look at, you are talking about the need for efficiency.
Yes.
Then we also need to look at the distribution of work. Why must it be that, some courts are overloaded, while others are not so busy? For example, vandalization of pipelines. This is exclusive for the Federal High Court. Unless the Attorney General gives a fiat to the state, they cannot handle such cases. So why don't we look at the redistribution of work? We need to look at the Constitution that gives so much powers to one court. So this court becomes so busy, whereas there are so many judges, many other judges, particularly state judges, that are not so busy. So we need to look at the configuration of power as a way, and then we should stop painting the judiciary with this brush of you are corrupt. There are so many of our judges that are doing excellent work that cannot be compromised. Many of our judges, the great majority of our judges, are not corrupt. So we need to begin to understand the difficult situation under which the judiciary is working, and then put in place measures that will enhance respectability, the dignity of the office. For example, retirement benefits of judges. Why should a judge have to wait for years before he can access his lawful benefit?
There are also complaints about debt of funds, even as the government is working towards effecting or giving bite to autonomy of state judiciary. What about the federal? Those at the federal level, are they also better off?
No, I think the federal judiciary is doing well
in terms of funding?
In terms of funding. It may be a difference in terms of how the funds are utilized, because I know that at the beginning of this administration, they were in the region of about 75 billion. And now they have moved up to about over 100 billion now. But the question is, this increase, this growth in the financial allocation, is it reflecting on the individual judges? Are the infrastructure improving? So we also have to look at issues of accountability within the judiciary itself. We need to look at that.
Okay, I don't know. This time, Justice Minister, let's discuss a bit of the Malibu oil deal. Apart from the former AGF advocate, who is now in your custody, who else has been identified and apprehended?
Well, you see, Malibu oil issue is an issue that has been on for quite some time.
Yes.
And it indeed involves chain of a chain of involvement, both local and internationally. As it is, the Office of the Attorney General has instituted an action in UK against one of the foreign banks that we believe was found wanting, or in a way or manner had compromised in its duties and responsibilities as a financial institution by way of allowing its system to be negligently used in the disbursement of funds in contention over Malibu. We have a pending suit against the bank internationally. We have pending suits in which we are actively participating in Italy, Milan, charging the IOCs, international oil companies that had in one way or the other, that were in one way or the other involved. And then we have local cases that are ongoing. So what we have tried to do is to cover the field in terms of ensuring that in whichever way our interest as a government, our interest as a nation is negatively affected, regardless of who indeed is involved, inclusive of the foreign financial institutions and high-profile financial institutions for that matter, we are in court with them.
Okay, I quickly, I will ask you if we still have sacred cows in terms of justice delivery. That will be your final question. But let me take a last question from the Justice Minister. So, what, in your opinion, you've listened to the raft of needs of the judiciary. What, in your opinion, is the greatest need of the justice sector today, and what should Nigerians expect?
Well, the independence is the major issue as far as the judiciary is concerned, and then funding. These two elements are the key elements that can effectively transform judiciary in terms of performance, in terms of general well-being. And I think as a government, we have identified those key needs and work in that direction. As stated by Professor Akinshayi, as it relates to the federal judiciary, it's a budgetary item and their budget goes to them directly. Yeah. In relation to the state judicial system, state judiciary, we came off with constitutional alteration, amendment to the constitution, the fourth alteration, that now re-established the rights of the state judiciary to direct funding as against an arrangement whereby they are subservient in terms of funding. So within the context of independence, we have done enough by way of ensuring statutorily the judiciary enjoys independence. Within the context of the funding, we have done enough by way of bringing about the desired amendment to the Constitution that sustains the independence of the judiciary at the state level.
What should Nigerians expect 2020?
What is unfolding now is what Nigerians expect. What is unfolding is the change of site and system from that of impunity to that of compliance, obedience to rule of law, and prevalence of law and order.
Finally, listen to this. Members of the bar, sometime last year, called veiled incursion from the executive arm as threatening, the independence of the judiciary. Just a few words on that from you. Very interested.
The NBA has taken a position. I go with the Nigerian Bar Association. We always want things to improve. Things are improved, but we want more.
So you think that there is a veiled incursion?
Yes, there must be. When it comes to relationship between the executive and the judiciary, we need more in terms of more space for the judiciary, in terms of independence, in terms of improved funding, in terms of support for the judiciary, then allowing them a free hand to do their work. I think we have made some progress, but there's still room for improvement. Yes.
Any word?
Well, we are making progress in all sincerity, and it's not out of place for the NBA to ask for more. But then it is equally important as well for the NBA to consider where we were, and then where we are today in terms of manifesting progress and development being recorded within the context of the obedience to court orders.
I think there's a meeting point. At least Professor Akishaya has agreed there is improvement.
Yes.
So we're getting somewhere. Yes. All right, Justice Minister and Attorney General of the Federation, Mr. Abubakar Malami, thank you very much for coming to Late Edition. And Professor Yemi Akishaya George, Senior Advocate of Nigeria, I'm very grateful to have you on my program. Gentlemen, thank you. And that's it this week on Late Edition. Thank you for watching. From me and my elaborate production crew, bye-bye.